Namaskar. Very good evening to all the viewers in this Sri Dattopanta Thengdi online lecture series. This is our 12th lecture, and I hope and I believe that all the viewers are enjoying this entire lecture series and getting benefited out of it. Today, we have a distinguished speaker, eminent lawyer, Mr. Sangram Desai. Who is also a bar council member. I request Advocate Yashodip Deshmukh to introduce our today's speaker.
Thank you, Pravartak. Good evening, viewers. Mr. Sangram Desai is member of Bar Council of Maharashtra and Goa, but he is a distinguished lawyer, very well known in the districts of Sindhudurg, Ratnagiri, Kolhapur, having handled large number of session trials and also in the state of Goa. He has also appeared before the Bombay High Court in several matters, and one of the famous matters was the Nando's murder trial, where initially, out of the 10 suspects, some 8 were convicted, and he had his role as an advocate in that matter was appreciated by the Honorable Bombay High Court. He has been active in this circuit of delivering lectures, even for the Bar Council conducted lectures and otherwise. We are very thankful to you, sir, for having spared time today, for accepting our invitation to share your knowledge, which comes from actual practice of session matters in different courts of the state of Maharashtra. But before I conclude the introduction of our distinguished speaker, I would also like to make an announcement of a novel event, a game being conducted by the Mumbai unit of the Adhivakta Parishad. The name of the game is Lossy. Viewers, you can follow our Facebook page for further details of this game. It is basically a housey game meant for lawyers, and that is why the name Lossy, that is Law Housey. It is a very fun-filled game which gives you an opportunity for academic study and also have fun with the other lawyers who you cannot meet physically today. So over to Pravartak now. Thank you.
Thank you, Yashodip. I am aware that all the viewers would love to participate in this game. I believe that Yashodip. And now I request to our distinguished guest speaker to deliver the lecture.
Thank you, Pravatak. Thank you very much. First of all, I thank the organizers for giving me an opportunity to share my views on the given subject. My friends, just before we are starting this session, I had a small talk with the organizers, and I was told that the time limit for discussing this subject would be around 30 minutes to 45 minutes. And my friends, considering the subject, dying declaration, I don't feel this is quite adequate time to discuss the subject of dying declaration. But still, I feel that this subject we can divide into 2 parts. The first part is the theoretical part of it, and the second is the practical approach when we are conducting a trial, how to use this section in either ways for the defense or the prosecution. So therefore, we have to divide this subject or this lecture into 2 parts. One is a very theoretical part, which is very important, by the way. Sometimes we just go theoretically and we don't know how to practically apply it. And sometimes we just go very practically, saying that, okay, we have to just falsify a few witnesses and we are done. But at that point of time, we realize the importance of theoretical part of it. So I'll try to touch both the sides of this dying declaration. Now, my friends, this word dying declaration is nowhere defined in the Indian Evidence Act. You will nowhere find a term called as dying declaration. So therefore, what is this dying declaration and where does it come from? My friends, we have to come or we have to go through the provisions of Section 60 of the Indian Evidence Act. And Section 60 of the Indian Evidence Act clearly state that a witness who has seen, heard, or perceived anything has to step in the witness box and state whatever he has seen, heard, or perceived. That is to say, that by the provisions of Section 60, the hearsay evidence is barred, is ruled out. And therefore, we have to understand we always call upon the direct evidence of a witness in any criminal trial. Now, there are only a very few provisions in which a go by is given to this basic principle of or underlying under Section 60 of the Indian Evidence Act. And that provision is, my friends, Section 32 of the Indian Evidence Act. We are dealing here with the provision of Section 32 of the Indian Evidence Act and more so Section 32 subsection 1. Now, when we say it's a dying declaration, in common parlance, we just understand as if a statement made by a person who is about to die. This is what is understood in common parlance. But in the eyes of law, it has a different meaning. Of course, it includes the statement made by a person when he's about to die. But then the provisions of Section 32, subsection 1 are relevant and very important. So I'll directly start with the provisions of Section 32. Now, this comes under Chapter 2 of the Indian Evidence Act as to the relevancy of facts. And I'll just read out Section 32 so that we understand. Now, Section 32 speaks about cases in which statement of a relevant fact by a person who is dead or cannot be found, etc., is relevant. Statements. Now, kindly see the every word of the statement or this section. It's very important. Statements, written or verbal, of a relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appear to the court unreasonable, are themselves relevant facts in the following cases. So, my friend, we are dealing here with a provision. What are the basic requirements for the first part of this section we have to understand? So, firstly, there has to be a statement made by a person who is dead. Of course, when he was alive. So, this is a statement made by a person who is dead. Now, what is this statement we are talking about? This statement should be of a relevant fact. So, this is the second important fact we need to understand, that it is not just a statement, but a statement about a relevant fact. Now, what is the third requirement? As I said, that the person must be dead. Now, if these basic things are satisfied, then this statement becomes relevant under Section 32, the chapter of relevancy of facts. Now, my friends, the further provision, subsection 1, we are dealing here with a person who is dead. So therefore, there are other subsections 2, 3, till subsection 8. But we are dealing here only with subsection 1. And what it says, when it relates to cause of death, when the statement is made by a person as to the cause of his death, now it is very important, kindly see the constructions of the word. When the statement is made by a person as to the cause of his death. So the statement should relate to the cause of his own death and not that of any other person. Next, or as to any of the circumstance of the transaction which resulted in his death. Now, my friends, this is very important. Normally, we construe it as the statement made by a person as to the direct cause of his death. No. In this provision under section 32(1), not only the direct cause of death, but the words used are, you have to very carefully read these words, or as to any of the circumstances of the transaction which resulted in his death. So it's not the direct cause of death, but there may be circumstances, a transaction which resulted in his death, and these circumstances of the transaction will also be relevant under the provisions of section 32(1). Further, in cases in which the cause of that person's death comes into question. So now this is again very important. It is not just any matter where section 32(1) can play a role. It is only in those cases, in those trials, I'll come to whether civil or criminal later on, in those cases where the death of that particular person is actually a fact in issue. And therefore, we have to understand that it is not just any case, any trial, but where the death, the cause of person's death comes into question. Now, my friends, in addition to this, there is a very important aspect of this provision. Now, this provision, even though originally it comes from the English law, in this part of the provision of section 32(1), it differs from the English law. And we have to understand that such statements are relevant whether the person who made them was or not at the time when they were made under the expectation of death. So I pause here. So we have to understand, we just call it as dying declaration, and therefore we assume that this statement must have been made by that person when he was under impression or apprehension that he's going to die. So under the apprehension that I'm going to die, a person makes a statement. So it is not only related to those circumstances, but the provisions of section 32(1) makes it very clear that such statements are relevant whether the person who made them was or not at the time when they were made under the expectation of death. So it is not a must, it is not a necessity that such person must be under the expectation of death. Now let's come to the later part of it. And whatever may be the nature of the proceeding in which the cause of death comes into question. Now, therefore, I said these two things are very important, and that is the basic difference between the Indian law and the English law. The difference between the provisions of section 32(1) of the Indian Evidence Act and that of the English law. Even though originally it comes from there, two basic differences are this. Number one, under the English law, the statement has to be made by a person who is apprehending his death. So therefore, the first requirement under English law is that the person who has made the statement is under the apprehension that he is going to die for whatever reasons. And he has a full knowledge, therefore I use the word apprehension. So he's going to die and he is having a full knowledge that he's going to die. This is number one. Number two, under the English law, the evidence can be given only in cases of homicidal deaths. Now, my friends, as far as Indian law is concerned, or as far as section 32(1) of the Indian Evidence Act is concerned, it need not be a criminal trial, much less a homicidal death. It can be a suicidal death. It can be an accidental death. It can be a civil suit for damages caused on account of a death of a person. So therefore, the scope of section 32(1) compared to the scope of the English law is quite larger, and therefore so many things are included. But the basic thing which is included here is that the person making a statement need not be under the apprehension of death. Now, the reason why I'm saying this is because it is always presumed that the person who is on the deathbed or who is going to die will not make a false statement. And therefore, under this basic assumption that the person will not meet his maker which lies in his mouth, this is the basic principle which we are talking about. Under this basic assumption that he's not going to lie because he's going to die, this provision was based on under the English law. But under the provisions of section 32(1), we have slightly enlarged the scope of giving the evidence. Now here, a particular statement made by a person, even though at that point of time when he made the statement was absolutely not under the apprehension of death, and after some point of time he dies, he passes away, then even though those statements will be relevant and admissible under section 32(1). For example, like in case of dowry deaths, a wife is talking, a wife has committed suicide, her husband is facing trial for offense under section 306, and during her lifetime, there is no time limit as such. During her lifetime, she's speaking to a mother, to a sister, and she's explaining to them what she's facing at home, the assaults, or any sort of cruelty that was made to her, that finally drove her to commit suicide. So therefore, here such statements also become relevant if they are directly connected to the death of that person. Now, my friends, there's one more aspect which we need to consider, that under the provisions of section 32(1), what should be in question? It is the death of that person which should be the subject matter of that particular trial or the subject matter before the court or the issue before the court. Now let's, for example, say that it is a person A witnesses an incident of murder of person B. Now this is very important. A person A witnesses a murder of person B. Now, therefore, B has already died. The police come and record the statement of A, who is a witness to that incident. The statement is recorded. And thereafter, because of some ailment or an accident, this person A dies or passes away. Now, the question is, the statement of witness A is very important insofar as the murder of person B is concerned, because he's the eyewitness and his statement has already been recorded by police or maybe even the magistrate. The question is whether that statement becomes relevant under the provisions of section 32(1). This is irrelevant statement because this statement was made by that person in regards to death of some other person and not the death of person A. And therefore, we have to fully understand this fact that this statement where the fact of the person who is deposing, whose dying declaration is recorded, if that is the fact or is the issue before the court, then it will be relevant under section 32 of the Indian Evidence Act. Now, my friends, these are the basic ideas of the provisions of or the ingredients of section 32 of the Indian Evidence Act. Now, the question is, there are so many other aspects. Now, who can record a statement under section 32 and in what form, and what are the different forms of dying declaration? This is a very normal question which might be asked. So there are a few ways and how a dying declaration is made. Now, the words incorporated under the provisions of section 32 are statements written or verbal. Now, my friends, kindly understand, the words are written is very clear, and written or verbal. So you have to understand this very important aspect. What verbal includes, we have to understand that. Number one, a statement made by oral statement made by a person who is about to die is heard by some third person. So it's a oral dying declaration. Number one. Number two, a statement not orally, for whatever reasons that person is not able to speak. His throat is slit, he has some other problems, he can't speak. So by signs, he makes a particular statement. Let us, for example, say 2 or 3 persons are before him and somebody asks him a question, or the magistrate asks him a question, who committed this offense? And he points towards a particular person. So it's a sign. By sign also, pointing towards somebody, he can make that statement. So one is an oral statement, one he can maybe by signs or any other mode make a statement. The third important statement is written. Like before his death, a person writes a suicide note, or as I was giving an example of a wife who committed suicide, she might be writing letters to her father, mother, sister, anybody, or a close friend. Now, all these written statements which, which show the cause of a death are all relevant under Section 32 of the Indian Evidence Act. So it's oral, it's written, it's by sign. Now, the fourth mode, according to me, is narration. Now, it is as good as making an oral statement, but a oral statement which has been written down, which we normally these days call as dying declarations, which is recorded by a magistrate or sometimes by a police. So, what happens in the circumstances if a person is admitted to a hospital? The police go there, they inquire with him, and if he's in a fit condition, they call the concerned magistrate to record the statement of that person. Now, here, a magistrate comes and the witness narrates, or maybe the magistrate asks him some questions, and that is recorded. So, it's the oral narration of the facts and being written down by a second person or a scribe, and thereafter, if he's in a condition to sign it, he signs it or puts a thumb impression or maybe nothing of it. So therefore, according to me, these are the four ways: oral, then written, by signs, and by narration, that is an oral statement which is written down. So these are the four ways in which a dying declaration can be recorded. Now then the question is whether any specific person has the authority to record a dying declaration. Now you will find a catena of judgments, different aspects of the dying declaration. And you will understand one important thing, that there is no such rule or authority as such by which only a particular person can record a dying declaration. Now, in the given circumstances, it may so happen that a person is seriously injured, he's been taken to the hospital, there is no time for calling the police or maybe the magistrate, who is the right person, whose evidence is always given at or weightage or importance. There is no time for that. In those circumstances, anybody can record a statement. So just a common man, maybe in the given circumstances, the evidentiary value of that dying declaration is a different thing. But still, any person can record a dying declaration. Even a police officer can record a dying declaration. A doctor can record a dying declaration because he is the person who is in fact there treating that particular person in the given circumstances. And lastly, the most important, he is on the highest pedestal, that is a magistrate who records a statement. And the reason why I'm saying that he is on a higher pedestal is because he has no axe to grind against the accused. And therefore, it is assumed, or let's say presumed, that he will be recording the statement of that particular person in an unbiased manner and the true version of what he's stating. So therefore, what I feel is, from the judgments what we will gather, is that anybody can record a statement. Now, in every case has its own facts. So I'll come to that later on. This is the first part of it. Now the question is how a dying declaration is recorded. Now, my friends, there is no pro forma, there is no particular procedure given as to in what format a particular dying declaration can be recorded. We have to understand here, it's a simple logic, it's a matter of common sense. By what we say, recording a dying declaration, we are just recording a statement of a person who is about to die. Therefore, there is no particular format of recording a dying declaration, but there are certain safeguards which we need to understand. And those safeguards are, first of all, if it is recorded by a magistrate, then it is expected that the dying declaration should be recorded in question and answer form. So, a magistrate may visit a person in a hospital or wherever he is, and he may ask question: if there are injuries, how are these injuries? How were these injuries caused? Who is the person? Or in what circumstances these injuries were caused to you? All sorts of questions will be asked, but it is preferred that the dying declaration should have a detailed recording of the questions which were asked to that person and the answers which were given by the person. The reason why I'm saying this is because a magistrate may ask a question in a particular context, and maybe the person who is a deponent, who is not in a fit state of mind, may answer that question in a different context. And therefore, in order to understand in what context that particular statement was made or the answer was given, it should be recorded in a question and answer form. It is again not a must, it is not a rule. It is a matter of prudence. It is a rule of prudence that it should be recorded in a question and answer form. Now, the next important aspect which we have to understand, my friends, is that it is not only the question and answer form, but the exact words used by the deceased or the deponent. Now, why I'm saying this is because many a times the deponent, they come from a particular background. A witness who is from a rural background will have his own way of expressing things or telling things, the words used, the sentences he makes, the way he speaks. So they have their own ways of it. And in order that the court gets the exact picture of what, or exact understanding of what he was trying to say, the words used by the deponent should be, as far as practically possible, be recorded in his own words. Now, my friends, sometimes it so happens that there is a magistrate who doesn't understand Marathi, or he understands Marathi, but he's not able to write Marathi. So he goes there, he asks a question to the particular witness or the deponent. He speaks in Marathi, but as he is not able to write in Marathi, he scribes it in English or Hindi. Now, this translation from Marathi to English or Hindi is the act of the person who is recording, that is the magistrate. So, therefore, in these circumstances, when it is not recorded in the actual words of the deponent, in these circumstances, after the statement is recorded, it should be read and explained it over to the deponent in his own language and understanding. And after he says that yes, whatever you written is right, after its accuracy is confirmed, only then it should be, or it should be signed. So this is the second aspect which we have to see. In case of a dying declaration recorded by a magistrate, of course, there has to be, definitely, he has to sign the deposition or the statement. But there are circumstances where, let's say, a person is set ablaze and there are burn injuries on his body or most probably his hands, he's not able to sign. In those circumstances, even the magistrate need not take the signatures or even the thumb impression. So it depends upon the facts and circumstances of each case, whether it has to be signed, whether a thumb impression has to be obtained, or whether without signing or even obtaining the thumb impression, that particular piece of evidence can be held to be admissible or a good evidence. So this is a different aspect. Now there is one more important aspect which we have to understand. The mental condition of the person who is deposing or is making a statement is one very important aspect. And my friends, you must have come across so many session trials cases wherein we challenge, we attack as defense lawyers, we attack on one important aspect, that the deponent was not in a fit condition to depose. He had no absolute uh, consciousness or understanding as to what he was saying. Maybe because he was under the influence of some medicines, or maybe he was badly injured, and therefore the fitness, the conditions in which the mental condition in which the deponent had made the statement is very, very important aspect. And therefore, normally it is expected that the prosecution should lead evidence to show that the person who had made the statement was in a fit mental state and understanding the questions and understanding what answers he has given. So this is another requirement of dying declaration if it is to be proved in the court of law. Now this is all about written dying declarations. What about oral dying declarations? My friends, it so happens sometimes a person who is about to die, there is no time for calling a magistrate, for calling police or anybody. And therefore, in those circumstances, even an oral statement made by that particular deponent or the person who is going to die, that these are the circumstances which led to these injuries. The statement, oral statement made by that person to another person, he need not be any particular class of person. He could be a friend, he could be a relative, he could be a doctor, he could be an attendant, he could be anybody, a police or a magistrate, anybody. So therefore, a oral statement made by a person who thereafter dies as to the cause of death is again relevant. Now, what is expected in this oral dying declaration? So here is a witness who will come and say that this witness stated this is what has happened. And that is what precisely I was talking about, that this is an exception to the rule of hearsay evidence. So he's just going to come and step in the witness box and say, I met this person at this point of time in the hospital or wherever. He was in this particular condition, and he told me that he was stabbed by A person or person B, whatever that person is, and in this particular manner. Now, this evidence becomes relevant. But what is more important is now this person will not be able to recollect the exact words. So, here the rule of prudence and the rule of caution is important, because it depends upon the intellectual understanding or the intellectual level of the person to whom that statement is made. So here lies the crux of the matter. He might have said something in one perspective, and the person who listened to it understood it in a different perspective. And therefore, in case of oral dying declaration, I feel there has to be certain amount of corroboration to the statement of that particular witness. In case of written statement, maybe it's not required to that extent. Now, what about a written dying declaration? Now, my friends, as I said, these might be letters or a suicide note. Now, these documents will have to be proved in a particular way. Like if it's a letter, then it has to be produced in the court. The handwriting of in that particular letter, it will have to be proved by proper maybe scientific evidence and identification of the person known to that person who has written the letter, or a suicide note. In these circumstances, the signature of that person and the authenticity of that document will have to be proved. So these are the basic broader ways in which a dying declaration can be proved. Now, my friends, there is one important aspect which we have to understand, that evidence can be laid in a particular way, it's fine. Oral statement, written statement, everything is fine. But what is the evidentiary value of a dying declaration? And this is a very important question. Now, I may be short of time, therefore I'm trying to cut short. But the fact is, the evidentiary value of we will go come across a catena of judgments. They will be dealing with different factual matrix of that particular case. And on the basis of the factual matrix of a particular case, those appeals or the cases will be decided. But the evidentiary value of any dying declaration will definitely depend upon the facts and circumstances of each and every case. Now, there is one important judgment which I normally never refer to the case laws, because I feel that it's a thing which you should do on your own and find out. Only then it helps you. But for explaining the basic principles of the evidentiary value of a dying declaration, I will refer to three judgments, and then I'll sum up. The basic requirement for the proving a dying declaration, a very important case, my friends, you'll have to, and this is Kushal Rao versus State of Bombay, 1957, lawsuits, Supreme Court, 93. This, I think, is the, if you see any of the judgment on the point of dying declaration, you will always find the basic principles embodied in this judgment will always be reproduced in almost all the judgments. And the basic principles or the conclusions drawn in this judgment are very important. It's a very short paragraph. 6 points are discussed, but the conclusion drawn insofar as the dying declaration is concerned. Now it says in para number 16 of the said judgment, it has been very clearly stated that it cannot be laid down as an absolute rule of law that a dying declaration cannot form the sole basis of conviction unless it is corroborated. So what is the first thing? That dying declaration can be a sole basis of conviction and corroboration is not required. There are certain safeguards which you need to have before relying on the dying declaration. But there is no rule of law which says that you cannot base a conviction solely on a dying declaration. And that's the first principle. Now, the second, that each case must be determined on its own facts, keeping in view the circumstances in which the dying declaration was made. So, as I was saying, it is depending upon the factual matrix of the case. For example, let's say if the prosecution is not able to prove that the person was in a fit state of mind, obviously we are not going to rely. And this is a peculiar fact of a peculiar case. And therefore, there cannot be a straight jacket formula for believing or not believing a dying declaration. Now, the third important aspect, that it cannot be laid down as a general proposition that a dying declaration is a weaker kind of evidence than other pieces of evidence. Now, this is again very important. We come across different pieces of different kinds of evidence. So it is said that dying declaration was made, it's kind of basically a hearsay evidence. So we should treat it like hearsay evidence. No. It says that it will be treated like any other kind of evidence. So it will be at par with a oral testimony of a witness. The fourth important aspect, that a dying declaration stands on the um, same footing as another piece of evidence and has to be judged in the light of surrounding circumstances and with reference to the principles governing the weighing of evidence. This is what I was discussing. Number 5, that a dying declaration which has been recorded by a competent magistrate. This is very important. A dying declaration which has been recorded by a competent magistrate in the proper manner, that is to say, in the form of questions and answers, and far as practicable in the words of the maker of the declaration, stands on much higher footing than a dying declaration which depends upon oral testimony, which may suffer from all the infirmities of human memory and human character. So this is what I was discussing. So if it is recorded by a magistrate in a particular way, then it has a great importance, because there is some sort of guarantee or assurance that there was a person who was not biased towards either of the accused or the complainant or the deponent, and he has just recorded the statement as stated by that particular person, and therefore a great weight has been attached to such statements. The next, that in order to test the reliability of a dying declaration, the court has to keep in view the circumstances, like the opportunity of dying man for observation, for example, whether there was sufficient light in if the crime was committed at night, whether the capacity of the man to remember the facts stated has not been impaired at the time he was making the statement by circumstances beyond his control, that the statement has been consistent throughout. If he had several opportunities of making a dying declaration apart from the official record of it, and the statement has been made at the earliest opportunity and was not the result of tutoring by interested parties. Now, my friends, the last point, point number 6 of this judgment, will open up a Pandora's box for the defense lawyers. Now, how many things have been mentioned? I mean, it's again a matter of common sense. When you are dealing with a dying declaration, what is the defense to be taken? In what way you are going to deal with the dying declaration? All these facts depends upon the circumstances of those particular cases. But then, what is the important fact that you will have to understand? Just because a witness comes in a witness box and proves that the dying person has stated this to me, and that does not mean that a case is proved. My friends, you have to understand this fact that by doing this, they might prove only one aspect, that the dying person had made this statement to this particular person. But whether that was true or false will always be challenged by the defense, and the prosecution will always be in a duty bound to prove by other circumstances and evidence that the statement is a true version of what has happened, and therefore it will not be accepted as a gospel truth in the given circumstances. And therefore, if you are able to prove, let's for example, there are 2 3 ways in which you can do it. For example, if a deponent or a person who dies later on makes a statement that a particular incident has happened in a particular way, but by other witnesses, you can bring it on record that the incident has not happened in the manner and mode in which the deponent has stated in his dying declaration. Obviously, if there is a contrary evidence, then there will be 2 sets of evidence on one important aspect, and therefore there will be a contradictory evidence on one important aspect, and therefore in these circumstances it will be disbelieved. Or let's for example say that a deponent makes a statement, a full statement, and first part of the statement he comes up with a particular case, and in the last part of the statement he makes a contrary statement. So basically there is an inherent infirmity in the dying declaration itself. So even though if it is proved by the prosecution witnesses, even by the magistrate, when there are basic inherent infirmities in the case, in the dying declaration, then it will absolutely not help the case of prosecution. Now, my friends, there is, as I was saying, there are so many other ways in which you can basically prove. Now, let's say if it's an oral dying declaration. Now, if you are able to prove that the person to whom that particular statement was made was interested witness, not just an interested witness, but is a habitual liar, or from his cross-examination you point out to the court, or you prove to the court that this particular has lied on a very important and a vital aspect, then the testimony of the person to whom this dying declaration was made will not be accepted, and thereby the dying declaration will not be the basis of conviction. You will always have a chance of acquittal. Likewise, there are so many other defenses. You can always cross-examine a medical officer and point out that the particular person was not in a fit state of mind to make a statement. Or nowadays, it so happens that when a witness is admitted, a person or a person who has been assaulted is admitted to a hospital, the first thing that happens is the medical officer asks questions to him. What has happened to you? You normally find it in any medical certificate. So that person gives a reason or explanation for his injuries. So that is the first statement made by that person when he's immediately brought to the hospital, or even before that. So when he's been brought to the hospital, from the place of incident to the hospital, he might be in the ambulance, make a statement to a relative of his. So I have come across so many cases where a person makes a statement when he was brought from the spot of incident to the hospital. Thereafter, the doctor inquires with him to find out the history of the case, and he makes a second statement. Thereafter, the police come, they inquire with him, they record his statement. This is the third statement, and thereafter, if the time permits, circumstances permits, a magistrate is called, and the magistrate records his statement. Not only that, but the magistrate may record not one statement, but maybe two or maybe three statements. So in these circumstances, you will find more than one statements, dying declarations of a person. Now, here in these circumstances, if you are able to point out the contradictions, not the omissions, or even the omissions, also the contradictions, or different versions of the same incident given in these different dying declarations, then you still may be able to convince the court that this is not a reliable piece of evidence. Now, my friends, I'll I'll just conclude this session with one important case. The reason why I keep on saying that there is no straitjacket formula for deciding the evidentiary value of a particular dying declaration is, I'll give a classic example. Now, I'm referring to a very famous case, Sharad Sarda versus State of Maharashtra. This is 1984 lawsuits, Supreme Court 176. Now, if I start reading, I'll take some time. But this is a very important judgment insofar as dying declaration is concerned, and more so, one dying declaration in how many ways it can be interpreted, or the scope, more specifically, the scope of Section 32(1) of the Indian Evidence Act. What comes within the ambit of Section 32(1), three judges have decided this. This is a decision of full bench of the Honorable Supreme Court, and it was presided over by Honorable S. Murtaza Fazil Ali, A. Vardarajan, and Honorable Sri Mukherjee. These were the three judges. Now it will be interesting. I don't have time to read it, but the scope of Section 32(1) is discussed in this particular judgment. The all the three judges have concurred on one aspect, that this is a case of acquittal and they have acquitted. But insofar as the scope of Section 32(1) is concerned, the first honorable judge, Justice Murtaza Fazil Ali, has observed that the letters written by the deceased to her sister, to her friend, and the statements made by the deceased. She was a wife who committed suicide, and before she died, she had written certain letters to her friends and relatives, and she had spoken over phone in person to her relatives about the harassment that was meted out to her when she was with her husband. So the Honorable Supreme Court was considering the scope of Section 32(1), and Justice Fazil Ali observed that these statements, oral as well as written, that those are the letters and the oral statement made to her sister and the relatives, are admissible under the provisions of Section 32(1). And more specifically, that is precisely what I was trying to point out. The reference was, or the reference was given to this statement when the statement is made by a person as to the cause of a death or as to any of the circumstances of the transaction which resulted in the death, in case in which the cause of person's death comes into question. So the circumstances of the transaction which resulted in the death, this was brought into action, and therefore it was held by Justice Ali that these statements are admissible under section 32(1). Now, my friends, you will also find that in the very same judgment, Justice Varadarajan has absolutely disagreed with Justice Ali and has observed that the statements made by the person to the relatives and the letters do not fall within the scope or the ambit of section 32(1), because according to him, they do not fall within the transaction, the circumstances of the transaction which resulted in her death. And then there is a third judge, Justice Mukherjee, who has observed that I agree with the observations of my brother Judge Justice Ali, but that there is no straitjacket formula. Those will have to be accepted in the given case, in the particular circumstances. They can be accepted and they cannot be accepted. So this is one judgment wherein the full bench of the Supreme Court, three judges, came to three different conclusions insofar as one set of evidence is concerned. And therefore, my friends, there will be always conflicting judgments you will find. So it is all depending upon the facts and circumstances of a particular case that you will have to prepare a defense, or the prosecutor has to lead evidence in a particular way. And therefore, you will not find any particular straitjacket formula. Actually, I wanted to rely on one more judgment, but I won't just read it out. I'll just give you the citation, maybe, because you will find it out. There are 11 important observations in this judgment. This is 2007, All MR, Criminal, page 847. This is a judgment by the Honorable Supreme Court, Justice Arjit Pasayat and Justice Ravindran, Mohan Lal and others versus State of Haryana. Mohan Lal and others versus State of Haryana, 2007, All MR, Criminal, page 847. I'll not read the observations in this judgment, but they have pointed out 11 important circumstances to believe or disbelieve, or the evidentiary value of a dying declaration. And for their every observation, they have cited a particular case why they are relying on these particular circumstances. So maybe this judgment will come to your help. And therefore, while concluding, as I was pointing out that there will be always, you will get different new facets, new aspects when different facts and the factual matrix of a case come before you. You will have to deal with that particular case in that particular way. And therefore, I always feel that you should have a theoretical knowledge of a particular provision of law, but the most important aspect is to practically apply the theoretical knowledge to the facts and circumstances of a particular case. And therefore, I feel that I have covered almost whatever I could in the given time. And therefore, I thank all the organizers for giving me an opportunity. And most important, a very good friend of mine, Advocate Parijat Pandey, who is also instrumental in asking me to come over for this series of lecture. Thank you very much. Before I conclude, an announcement was made just before we started about the new game, which is like Housey. And I feel all of you should participate, because even when they were explaining this new game to me, it is about the different kinds of judgments and on which subject these judgments deal with, or which subjects are these judgments on. So it will be like a quiz, and by playing this game, maybe, not maybe, of course, definitely, we will again go through all these judgments and the basic principles laid down in these judgments. So therefore, I request all of you that you also should participate in laws. I hope that's the same thing. And I thank you all again for hearing me patiently. And I thank the organizers also. Thank you very much.
Thank you so much, sir. That was quite enlightening experience. Sir, we have a few questions, though we are running out of time, but still, since there are questions, I request you, can we deal with it?
Yeah, definitely. You can.
Yeah. So the first question is by Advocate Chandrakant Sawan, sir. He asked, in a dowry death of a dying declaration, in a dowry death, if dying declaration is made by deceased after relatives discussion with deceased, what is the evidentiary value of it?
So, as I was telling you, the sixth observation of the judgment which I cited, it says that if there is a chance wherein a witness is tutored, just because they were present doesn't make it uh, unbelievable or something like that. But if there is a chance that the witness, relatives or the witnesses are there, and they tutor that particular witness, and you can bring it out through cross examination or other circumstances that the witness, the the deponent was tutored to tell particular thing, and it is not the truth. Definitely, it will have a lot of bearing on that, and it might help the defense that to show that this is not the truthful version of what actually happened. Yes.
So the next question is whether endorsement of doctor is necessary at the beginning as well as at the end of dying declaration. Whether
No,
certifying
I
doctor
missed
should.
your first part. I missed your first part. I couldn't listen to you. Can
So
you
the
just repeat the
question is,
question?
yes, whether endorsement of doctor is necessary at the beginning as well as at the end of dying declaration.
Okay,
Whether
well, yeah.
certifying doctor should depose in witness box that's stated by deceased before him.
Okay. So there are two
Question
parts of
for
this
addition.
question. The first part, whether there has to be an endorsement, yes. If the witness is admitted in hospital and examined by a particular doctor and is making a statement, it is always advisable that the doctors makes a endorsement, maybe not at the starting and the end, but he makes an endorsement that the person was in a fit condition to give the statement. Sometimes it so happens that while the witness starts deposing, initially he is in a fit state of mind, but during the course of recording of that deposition, he might not be in a fit state of mind. And therefore, it's advisable that there has to be endorsement at the starting and the end. But again, it is a rule of prudence. It is not mandatory at all. The doctor may just come and say that yes, he was in a fit state of mind. That's it. Now, the second part of the question, as I understand, is that whether the doctor should be examined. Now, again, this is again a rule of prudence. You will find judgments wherein it has been held that even though the doctor gives a certificate that he was not in a fit state of mind, but there are eyewitnesses who say, or there are witnesses who say that the deponent made a statement to me, and when the statement was made, he was in a fit condition. The court has gone to extent to believe those witnesses to whom the statement was made and not the doctor. So therefore, you will have to make all the efforts to show that from the doctors you positively bring out that this person was not in a fit state of mind to depose as stated in the dying declaration.
So the next question is by Advocate Amul Joshi. Whether FIR
Yeah.
can be considered as a dying declaration if informant dies.
Yes, definitely. FIR can be considered as a dying declaration if the deponent dies. It is obviously a statement which will be considered as a, of course. Now, there are two things. We are assuming and presuming that the statement which has been made is, of course, if it's an FIR, it will be definitely mentioning about that particular incident. Though at that point of time he was not knowing that he's going to die, but definitely it will be considered as a dying declaration. Yes.
So the last question by Advocate Gyanchand Maurya, whether mobile video recording of a dying person by the person other than magistrate just after the incident is valid evidence or not, and what required to be proved.
Okay, now this is a very good question. Now I think, sorry, can I say? Yeah. Okay. As per the Information Technology Act, now the electronic record is defined as a document. Now it's as good as a document, right? So therefore, this is a very interesting thing. Now his oral statement has been recorded, but it will be proved like a document. That electronic record of that particular oral statement or whatever he said, if it has been videographed or audio clipping is there, it will be proved in the court as per the provisions of Indian Evidence Act and the Information Technology Act as amended by the Information Technology Act. And obviously, they will be relevant because, of course, then again, that statement has to be made in which the cause of his death or any circumstances of transaction relating to the cause of his death will have to be mentioned in that video or the audio recording. Then definitely it will be admissible and it will be held as a very good evidence. But the defense always will have a chance in cross examination to show that it was manipulated. But yes, it can be held as a good piece of evidence.
Thank you so much, sir. Now I request Advocate Saloni Gule for vote of thanks, and she will also explain the idea behind this law housing game. I request Advocate Saloni Gule, please.
Hello, thank you so much, sir. Thank you so much for the insightful session and explaining the legal concepts of dying declaration and also apprehension of death. A special thanks to the social media platforms for making this gathering possible, also the internet connection. And last but not the least, the viewers, you really keep us going. So keep on watching, keep on viewing. And now coming down to because of your encouragement and because of the social media platforms, even during these times when we are under lockdown, we have curated at Akhil Bharatiya Adhivakta Parishad, Mumbai unit has curated a game for you where we meet up. Our legal fraternity meets up and has a chance of interacting and having a fun-filled academic exchange. So, a game called Lozy, Legal Housing. So, how does that work? We give you a list of 90 case laws. From the list of 90 case laws, you select any 20, and from that 20, you prepare your list, your table, and upload it in the Google Forms that we are circulating off the web. All the resource material is available on our official pages. Do check that out. So the registrations are open till 24th of May at 11 p.m. And the main game will be held on 26th of May at 4 p.m. Do participate, more the merrier. And like I have been saying in the tutorials, let's socialize during this physical distancing. Thank you so much.
Thank you so much, sir. It was really a wonderful experience. And now I request all the viewers to kindly follow our Facebook page, our YouTube channel. Kindly share, like, and subscribe. Thank you all.
Thank you so much.